matter of Cornerstone Telecommunications Infrastructure Limited and the University of London.
Good morning, my Lord. I appear on behalf of the appellant with Jonathan Wells of Counsel, Mr. Ziedler and Mr. Oliver Radley Gardner appear on behalf of the Respondent. It's my appeal from the decision of the upper tribunal. May I inquire the material that your lordships have had an opportunity of reading, and in particular the code? You know, my Lord Justice Lewison is
we've looked at the skeleton arguments, we've looked at the judgment below, so I think we're familiar with the issues.
Thank you. I was proposing, subject to what your lordships say, to refer in particular, just for reference purposes, to the following provisions of the code. So if your lordships are concerned about any of those provisions, please inform me and I can then look at those in detail with you. But I was referring to, for noting purposes, paragraphs 3, 4, 20, 21, 22, 23, 24, 25, 26, 27, 30, and in particular 30 subparagraph 3. Perhaps if we canter through those now, and if your lordships indicate you're familiar with them, then we can move on. The code is contained in tab 17 of the second bundle of the authorities, and apologies, is not particularly conveniently placed. It's behind another part of the Communications Act, and one has to go to a page at the top right hand corner of page 593, my lords. Thank you. So we start off with paragraph 3. That's the menu of code rights. And if your lordship see, it refers to code right in the singular. It's a menu. And so an operator can seek any one of those. It is, in my experience, since the code has come into force, the universal practice for operators to claim every single code right that one seeks in the notice of claim.
I thought the right to lop trees is of any great importance in this particular case.
I agree with you, my lord, and there was cross-examination about the number of trees that were located on the roof of the subject property. And of course there were none, or none that were going to interfere. But that is the way operators operate. I think there is a concern that unless all rights are claimed, they'll miss out. But that is my experience. So these are the rights, and we are going to be concerned in particular with subparagraph 3A, to install, and if I may abbreviate electronic communications to ECA, so to install ECA on, under or over the land. We're also then concerned with D, to carry out any works on the land for or in connection with the installation of ECA on, under or over the land or elsewhere. And then we see also the lopping of trees, because that is prayed in aid by the respondent as a reason for why their construction is to be preferred, but it's a right to lop or cut back. Notice it refers to cutting back and lopping. It doesn't refer to removal or felling. I say that because when we come to discuss that, we can think about the examples where that right may be of benefit or not, as the case may be. Paragraph 4 is the statutory purposes. And before looking at paragraph 4, if we go back to the beginning of paragraph 3, you will see that the opening words of paragraph 3 are, for the purposes of this code, a code right in relation to an operator and any land is a right for the statutory purposes. So the right is an operator. An operator is someone upon whom there's been a direction under section 106 of the Communications Act 2003. CTIL is an operator within the terms of the Communications Act. So you have an operator, it has to be a right over land, and it has to be a right for the statutory purposes. And therefore, when we look at paragraph 4, we will see that the statutory purposes are one of two possible purposes. The first is providing the operator's network, and the second is providing an infrastructure system. I didn't mention this paragraph in my crib, but paragraph 7 defines infrastructure system, not particularly helpfully, but there it is.
We're at purpose B, aren't we? Because Cornerstone doesn't actually operate a...
They do not operate a network. That is so, my lord. That is so. That is so. Yes, they do not operate their own independent network, as may have been gleaned from the judgment. CTIL is a company owned by Vodafone and Telefonica, 50% each, and CTIL operate what's called the passive infrastructure. So they own that, and then Vodafone and Telefonica operate their own networks from that passive infrastructure. So yes, my lord, so there's a definition of infrastructure system. We don't need to detain ourselves too much on that. And then paragraph 20, we have the paragraph dealing with the court power to impose an agreement. You will see it's under what's called Part 4 of the Code, Power of Court to Impose Agreement. And your starting position is that you seek agreement with the occupier for the time being. That's been the subject of recent determination in this court in CTIL against Compton Beecham, which isn't in the bundle. We may have to look at it, but not in any detail. So if you're unable to reach an agreement, then the operator can then make an application under paragraph 20 for imposition. Although it refers to court, we know from the regulations that the relevant court is the upper tribunal. That the proceedings must be issued or referred in the upper tribunal. So we have paragraph 20. The paragraph applies where the operator requires a relevant person to agree. And as I say, my lords, the meaning of relevant person has been the subject matter of a decision in this court in CTL against Compton Beecham. So you either agree to confer code rights or otherwise be bound by a code right. And then there's a notice you have to give in subparagraph 2. Operator may give the relevant person a notice in writing setting out the code right and all of the other terms of the agreement that the operator seeks. Note, as we look at that, that it is the operator that dictates initially the terms that it wants. It sets out the code right and all of the other terms of the agreement that the operator seeks. And then he seeks that person's agreement to those terms. And then subparagraph 3, the operator may apply to the court for an order under this paragraph if A, the relevant person does not before the end of 28 days, beginning with the day on which notice is given, agree to confer or otherwise be bound by the code right. Or, at any time after the notice is given, the relevant person gives notice in writing to the operator that that person does not agree to confer or otherwise be bound by the code right. So, if there's an earlier indication that the agreement of the relevant person is not going to be obtained, and that is indicated in writing to the operator before the expiration of the 28 days, the operator can go to the upper tribunal and issue its reference earlier than the expiration of the 28-day period. And then subparagraph 4 tells us what an order under paragraph 20 is. It either confers the code right or provides for the code right to bind the relevant person. Then paragraph 21 is the test, and this is important for our purposes. So in paragraph 21, subject to subparagraph 5, the court may make an order under paragraph 20 if and only if the court thinks that both of the following conditions are met. The first is that the prejudice caused to the relevant person by the order is capable of being adequately compensated by money. 2, or subparagraph 3, the second condition is that the public benefit likely to result from the making of the order outweighs the prejudice to the relevant person. 4, in deciding whether the second condition is met, the court must have regard to the public interest in access to a choice of high quality electronic communication services. 5, the court may not make an order under paragraph 20 if it thinks that the relevant person intends to redevelop all or part of the land to which the code right would relate, or any neighbouring land, and could not reasonably do so if the order were made. Just pausing there for a moment, that particular subparagraph has been the subject matter of consideration by the upper tribunal in E and Hutchinson H3G against the Merrick estate, where, that's in the bundle, paragraph 38 of the report refers, but the court, the upper tribunal, determined that the case of the body of case law under the 1954 Act relating to an intention to redevelop under section 30 subsection 1F of the 1954 Act was a body of law to which reference could be made in considering this paragraph, subject to suitable adaptation because of the time period. And second,
That's not an issue in this case.
it's not an issue in this case, but just for your Lordship's knowledge. Well, it's not an issue in this case, but it does come in indirectly with respect to the sidestepping of the test. And I've mentioned that in my skeleton, that one of the difficulties with the respondent's case, it can sidestep this test, we say, to the disadvantage of the site provider.
If all that is being asked for is an MSV, is there any likelihood that the conditions laid down in paragraph 21 will not be satisfied?
Subparagraph 5 may not be satisfied. It is also the case that it depends on what the subject site is. With respect to the subject case before your Lordships, we're dealing with a roof. Of course, the code can apply to all sorts, a myriad of sites. For instance, let us think of a forestry. The site provider, is operating a forestry business. A forestry business, growing trees. The MSV may have some impact on that, and it may be that one can think of circumstances where the prejudice caused to the relevant person may not be adequately compensated. There may be, for instance, particularly sensitive buildings, government buildings, buildings which are being utilised for national security. Because the one thing to note is that the code applies to all land, residential premises, commercial premises, crowned land. I have not been able to find any exemption with respect to the land to which the code can apply. So in response to your Lordship's question, there may be particular sites, depending on the nature of the site, which may not satisfy that test. And it may also be that subparagraph 5 is not satisfied, because there may be an imminent redevelopment where the MSV may impact on that. There was some discussion in this case about that, but it was too far off.
It's not in dispute, though, is it, that even under 26, there can be conditions attached.
There can be conditions attached.
So, I mean, all that could be taken into account by the imposition of conditions.
With respect, no, my lord, no, because in relation to 26, when we get to that, we see that there has to be a good arguable case that you satisfy paragraph 21. Yes. If one is suggesting that conditions can be imposed, if it is the case that the conditions in subparagraphs 2, 3 and 5 are not satisfied, you cannot establish a good arguable case that those conditions will be satisfied, then you don't meet paragraph 21 test. And if you cannot establish a good arguable case for the paragraph 21 test, you don't get a paragraph 26 order.
But then there's no problems there. So I'm trying to understand your issue, why it's so important. This is all part of your case that you have to go on to paragraph 20. You're emphasising
Yes.
various conditions under 21.
Yes.
I understand that. And the point you seem to be making now is just testing your case.
Yes.
The point you seem to be making now is that, well, there may be a big issue in relation to 21. We talked about 21.5.
Yes.
And then you talked about, in answer to my Lord's question, you talked about there are some buildings which are particularly sensitive, or something may be going on there, or you may be able to sidestep the 54 Act type case of redevelopment and so on. And all I was asking you was, well, how realistic a problem is that? Either because, as you say, you won't satisfy the good arguable case test, in which case you won't get the right anyway, Or, if you do get up to 26, I thought it was common ground that the court can take into account particular circumstances and impose conditions.
Yes, they can impose conditions, and as your lordship says, if it is the case that the nature of the site is such that you do not meet the threshold, even at a good arguable case test, you don't obtain your paragraph 26.
So I'm just trying to
Yes.
test to what extent these are practical.
Well,
we can all think up lots of
we are
different
still in
examples.
the infancy of the jurisdiction and the infancy of the code. There have only been 9 cases that are reported in the upper tribunal, one of which it had a preliminary hearing. So in fact, there are only 8 reported cases, and this is only the second time.
Well, let me make it more
We've
difficult.
observed this.
Let me make it a little bit more trying for you.
Please.
Can you please give me an example of a case which does get over the good arguable case test, where the court could impose conditions, but nonetheless, because there is some issue in relation to what would otherwise be 21, the result would be unsatisfactory for the landowner?
I'm not able to think of an immediate example of that. I will consider that. I'm able to think of an immediate answer as to where you satisfy the threshold. Conditions are then imposed, but the conditions are unsatisfactory to the site provider. I can see
Perhaps
that.
your learned junior can be thinking
Well,
about that.
one can think about that. The only case where a condition has been imposed is a condition in relation to the obtaining of planning, and that related to a property which consisted of a residential block of flats.
But you wouldn't need that for an MSV.
You wouldn't need that for an MSV. Possibly. Well, you may need conditions.
You're talking about the sort of case where an operator says, I want to see whether the roof of MI5 headquarters is suitable for a mast, and I want to walk in and have a look.
Yes.
And there may be problems about that.
Well, there may be problems about that. I understand that a notice was served with respect to New Scotland Yard. I don't know what happened or what the outcome of that was, but I understand a notice was served for an MSV with respect to that property.
But is there power in your submission to deal with that kind of problem by imposing a condition such as that the MSV or the installation, as the case may be, has to be carried out by people who have an appropriate security vetting?
Yes, that could be imposed, and in relation to this particular site, the university site, of concern to the university was, of course, the occupants of the building, students, young persons, male and female, and of course, what one did not wish to have is unsupervised access. Having been at the site myself, obviously it's a rabbit warren of corridors where someone could easily sort of disappear, so you would need someone to supervise. I accept that there are conditions that can be imposed. I should give some thought to your lordship's question.
The important point is that obviously we construe interpret the Act. We can do it in a literal way or a purposive way, but we want to make sure that what we understand are the practical implications
Yes, I
of
follow
anything
that.
we do decide.
Yes. Well, that was paragraph 21. Paragraph 22 is simply the effect of an order imposed. It takes effect as an agreement between the parties under part 2. Paragraph 23 relates to the terms that the tribunal may order. Paragraph 23, subparagraph 1, an order under paragraph 20 may impose an agreement which gives effect to the code rights sought, with such modifications as the court thinks appropriate. And then 2, an order under paragraph 20 must require the agreement to contain such terms as the court thinks appropriate, subject to paragraphs 3 to 8.
Can I just pause a second? If the parties have agreed, well, they impose an agreement, then it says with such modifications as the court thinks
Yes.
appropriate. How does that? What are the modifications
Well,
to? What sort of things would they
we
be?
saw from paragraph 20, subparagraph, subparagraph 2, that the operator serves his notice, setting out the code right and all of the other terms of the agreement that the operator seeks. Yes, and so then the court has to then try and give effect to that. Now, the modifications can consist of a number of matters. Let us say that the provision, there's one provision, for instance, will be indemnity in relation to risk. So the agreement may contain that the operator is putting forward a provision that relates to indemnity with respect to risk going on site.
Well, the other example is the one you gave, that they say we want to do an MSB, and you say yes, but you can only have supervised access.
Yes, supervised access. Costs for the provision of supervision, hours of supervision, hours of access, not 24 hours, it's a limited period. For instance, not weekends, during the day. There may be a number of conditions that could be imposed with respect to the right sought or the modifications.
That's fine.
That is so.
Thank you.
So subparagraph 2, sorry, I think we mentioned that. So the agreement may contain such terms as the court thinks appropriate, subject to subparagraphs 3 to 8. And for instance, one of those, the terms are then elaborated upon over in the following subparagraphs. Subparagraph 3 relates to consideration. Note, it says the terms of the agreement must include terms as to payment of consideration. And then you have paragraph 24 reference in subparagraph 4 that elaborates on the consideration. And then subparagraph 5 says the terms of the agreement must include the terms the court thinks appropriate for ensuring the least possible loss and damages caused by the exercise of the code right to persons who occupy the land in question, own interest in that land, or are from time to time on that land. And then 7, terms of the agreement must include terms specifying for how long code right conferred is exercisable. And then 8 is what is commonly known as a lift and shift. The court must determine whether the terms of the agreement should include a term permitting termination and B, enabling the relevant person to require the operator to reposition or temporarily to remove the ECA to which the agreement relates. Then 24, we do not need to spend too much time on that. That's an elaboration of how the consideration for the imposition of the agreement is assessed. And there's we don't need to go into that.
I mean, the position.
One needs to know.
Your clients say not enough, and they say it's enough.
That is one issue, I suppose, in relation to consideration. It's a common issue, unfortunately. Yes. In this new piece of legislation, it's the thing that has polarised the operators.
That all lies in the future.
But that all lies in the future. Although, yes, that all lies in the future. There has been guidance from the upper tribunal and useful guidance. So then we have compensation 25. We can, as it were, skim that in the sense that just be aware of that. That provides for compensation with respect to the result of the exercise of the code right. And then 26, which no doubt your lordships have looked at in some length. So 26, an operator may apply to the court for an order which imposes on the operator and a person on an interim basis an agreement between them which confers a code right, provides for a code right to bind that person. 2, an order under this paragraph imposes an agreement on the operator and a person on an interim basis if it provides for them to be bound by the agreement for the period specified in the order or until the occurrence of an event specified in the order. 3, the court may make an order under this paragraph if and only if the operator has given the person mentioned in subparagraph 1 a notice which complies with 22, stating that an agreement is sought on an interim basis, and A, the operator and that person have agreed to the making of the order and the terms of the agreement imposed by it, or B, the court thinks that there is a good arguable case that the test in paragraph 21 for the making of an order under paragraph 20 is met. So we will be looking at that in more detail later, but the threshold...
Why is the intervention of the upper tribunal necessary if the person and the operator have agreed?
One can only speculate with respect to that, which is that there must have been a concern, as for instance in the 54 Act, as previously was the case when you went to the court to obtain an agreement with respect to excluding security, that there must be some supervisory jurisdiction, that the court should have at least an opportunity of considering what is being entered into to avoid abuse. That's all I can. It's a speculation, but I haven't been able to find anything specifically as to why it was considered that the court needed to have a supervisory jurisdiction with respect to agreement. One point to note is that I believe that the respondent has misunderstood our case to the extent that I think it's suggested in their response to my revised skeleton that we, the appellant, is suggesting that it is unnecessary to serve a paragraph 20 notice. That is to say, it is where there is an agreement with respect to paragraph 26. It is not parasitic on a paragraph 20 notice having been served. We do not say that. We say that there still has to be, even in relation to an agreement, a requirement to have a paragraph 20 notice claiming a imposed code agreement. The agreement is not displacing the opening words of subparagraph 3. Paragraph 3 still requires you to serve a notice which complies with 20 subparagraph 2. And then either A or B. So either you then have an agreement or you have an imposed order meeting the good arguable case threshold. Then subparagraph 4 informs us as to which provisions apply to the interim order, and those are then set out. Then subparagraph 5 deals with the time limit. The time limit, as you will recall, was the 28 days.
Can I just pause here?
Yes.
I think there may be some confusion here. You can apply, under 26.1, you can apply to the court for an order. And then once you've applied to the court for an order, you can reach an agreement. And then that has to be sanctioned by the court. But there's nothing to stop you completely outside the Act, just having an agreement if you wanted to.
That's right. Well, under paragraph 20.
The only reason the court's involved is because you've applied to the court for an order. And then the court is vested with it. Anyway.
Well,
but there's no suggestion you can't, outside the Act, just agree, as anybody can agree,
yes,
how you deal with your property.
Yes, that is so. I'm not suggesting you cannot do that. But what I am stating is that when you look at subparagraph 3, that in relation to the order by the court, where there is an agreement, you do need a paragraph 20 notice. That is what it says. Where the court makes the order, subparagraph 3.
Well, does it say that? It says a notice which complies with paragraph 20 sub 2.
Yes.
So it's only subparagraph 2 that you have to have your notice compliant with, not the remainder of paragraph 20.
Well, subparagraph 2 is the triggering provision. That's the substantive provision to trigger paragraph 20. That is your trigger notice. There's no other provision in paragraph 20 that identifies the triggering provision.
Your case is, yes. On your case, why, it's an odd way, if it's correct that you have to go, it's all part of the what I could call the paragraph 20 process, which is your case, it's all part of the paragraph 20 process. I mean, it's a very odd, you might be saying it's a very odd thing for them to incorporate that by saying there has to be a notice which complies with 22. Why don't they simply say, well, paragraph 20 applies to this, paragraph 20 applies to an interim order, or something of that kind?
Well, they have, I would submit, we would submit, because it is a requirement that it complies with paragraph 22. Sorry, my lord.
There is a difference in language between 26.3 and 27.1, which refers to a notice under paragraph 20. Is there any significance to be attached to that contrasting language?
Lordship is referring to,
Paragraph 27(1)(f).
yes,
This applies
under
to
paragraph
operating
22.
activities under paragraph 20, subparagraph, as opposed to notice which complies with paragraph 20, subparagraph.
Yes. That on first impression, I would submit that there is no material difference. It is to be noted also that when we go back to 26, we do have the provisions of paragraph 20 being applied in relation to subparagraphs 5 and 6, subject to, sorry, paragraphs 5 and 6. The following provisions apply in relation to an order under this paragraph as they apply in relation to an order under paragraph 20. So then 20 sub 3 relates to time. Subparagraph 4, my lord, of paragraph 26.
Yes.
And our submission is that when you look at 26, I'm jumping ahead now in relation to the argument, but I'm happy to sort of go out of order. But in relation to 26, an important provision in our submission is in fact 26.6. 26.6 is sort of tucked away there, and it relates to the consideration and terms. But you notice it says paragraphs 23, 24 and 25 apply as if, and then B, the duty in paragraph 23 to include terms as to payment of consideration to that person in an agreement were a power to do so. Now, your lordship saw when we were looking through paragraph 23, subparagraph 3, that the term of the agreement must include, as a mandatory requirement, must include terms as to payment in 23, subparagraph 3. Now, one can ask, therefore, the rhetorical question, why is it that the draftsman has identified the fact that the duty is now only a power? And we submit that is entirely consistent with the fact that there is a pending paragraph 20 claim, because the whole point of paragraph 26 we submit and will be submitting is that it is to do or deal with early access where there is or was a lack of agreement with respect to value. The parties, the operators wanting to get on site, we'll see this from the Law Commission commentary, but the purpose behind these provisions is to enable the operator to have early access. So one of the impediments to early access was the difficulty, the delay inherent in dealing with consideration to go in. And to avoid that, provision has been made to enable the operator to go in early and have consideration dealt with later. And we say that subparagraph 6 reflects the fact that this is intended to be a pending interim claim, because you don't, what is being disapplied is the duty. It's only a power. And the reason why the draftsman has identified it as a power is because there is no need, therefore, there's no mandatory requirement at the, if one could call it the interim stage, to determine consideration, because that is going to be dealt with later, namely at the paragraph 20 claim. That's the premise of subparagraph 6 in our respectful submission. And then we also, as you have probably read in the skeleton, place emphasis on the terms of subparagraph 7, because subparagraph 7 applies subparagraph 8, where the period specified or the event has expired without, in either case, an agreement relating to the code right having been imposed on the person by order under paragraph 20. Now, what it doesn't say is without an application being made under paragraph 20. It doesn't say that because it presupposes that this is a pending interim claim. Then we have 27.
Just before
Sorry,
we
my
leave
lord.
26,
Yes.
can I ask you one other question, Mr. Clark? Paragraph 26(2) requires the order to provide for it to be binding for a period specified in the order or until the occurrence of an event. But subparagraph 4 tells you that paragraph 23 applies, and paragraph 23, subparagraph 7 tells you that the terms of the agreement must include terms specifying for how long the code right conferred by the agreement is exercisable. So what does paragraph 26(2) bring to the party that paragraph 23(7) doesn't?
Well, it may be that what is being contemplated by subparagraph 2 is that you have the interim right is invariably going to be sought. In the normal case, it is going to be sought pending a paragraph 20 claim. And one of the provisions that one would expect and is dealt with essentially by 26(2)(b is that you would anticipate that the interim right is ordered to continue until trial or further order.
But why couldn't you do that under paragraph 23(7) by saying this code right is exercised
I see.
until determination of the paragraph 20 application?
So what your lordship is suggesting is that it's superfluous, that one could have dealt with it by 23. What else is it seeking to bring in? Well, I suppose that looking at the wording, subparagraph 7 of 23 is informing us that it must include terms for how long it is going to be exercisable, and then what subparagraph 26 is informing us is for how long the interim right is going to last. So 23(7) is imposing a mandatory requirement that the court must impose a time limit, and then 26(2) is indicating that the time limit can be one of the two following ways. Now, I see what your lordship is saying is that 23(7) could of itself have dealt with.
Because subparagraph 26(4) says that the listed provisions apply in relation to an order under this paragraph as they apply in relation to an order under paragraph 20.
Yes.
So
I see what your lordship is saying, but if one draws the analogy with an interim injunction, and that, of course, with an interim injunction you have to have a substantive cause of action. The claim is pending the trial of the substantive claim. And what the draftsman is doing in 26(2) is indicating the ambit of the continuation of the agreement. Yes, I accept that looking at subparagraph 7, it is possible that one could seek to interpret subparagraph 7 as suggesting that it could be until a certain period. But of course, one must remember that paragraph 20 subparagraph 7 in isolation, 23 subparagraph 7 in isolation is dealing with paragraph 20 court-imposed agreements. So that's dealing, as it were, with a substantive claim. What 26 is dealing with is what's happening on the interim level. And that's why the draftsman... Sorry, my lord.
I thought the point was that this is going, that what is being sought here is indeed a code right.
Sorry.
So you're saying that 20 is dealing with the end, is dealing with the end result.
20 is dealing with the substantive claim for the code right. Paragraph 26 is dealing with the code right on an interim basis. So if I wanted to just take a normal case, forget the multi-skilled visit. If I wanted to install electronic communications apparatus on a roof site, in order to do that, I need the agreement of the occupier. If that's not forthcoming, I then make my claim under paragraph 20. to have that installation, or the agreement to install it, imposed on the occupier. In the interim, I am entitled to go to the tribunal to seek an interim right to the same effect. Interim pursuant to paragraph 26. And for the purposes of paragraph 26, all I need to do is to satisfy the good arguable case threshold. And it's only a good arguable case threshold, we say, because it's pending the trial of the right that you seek. Otherwise, there is no point behind paragraph 20. Every operator will be seeking to operate paragraph 26.
No, I think we're, right, I'm slightly confused, it's my fault. I thought that your case was that in a situation like the present one, where the operator wants to see whether or not it wants to install, to make an installation on the property, but doesn't know whether it will or not until it's seen the site and surveyed it, that the test to be imposed was the test effectively under 20, weighing up the public benefit. Have I got that wrong?
No, your lordship has that right,
Right.
but only to a good arguable case. Yes, for interim, the operator only has to establish the paragraph 21 test to a good arguable case.
Right.
So we asked them, as it were rhetorically, why have the lower threshold? It's like an interim injunction. If you have an interim injunction, you have to show American Sign Language. Yes, there's a serious issue to be tried.
Yes.
You're going to have a substantive hearing. The threshold test is much lower when you make a claim for an interim injunction, because there's going to be a
There's no
substantive
dispute
hearing.
then, it's a good arguable case in relation to what may follow. You're not disputing it's a good arguable case, that's the standard. It's not weighing up the public benefit point.
No, my lord, apologies. It may be the way I expressed it. It's a good arguable case that the test in paragraph 21 for the making of the order under paragraph 20 is met.
Yes.
So what you have to do in order to obtain an interim right as an operator is that you make your case out that the paragraph 21 test, money's adequate compensation, public benefit, no intention to redevelop, that the entitlement to seek the paragraph 20 right would be met on a good arguable case basis. You have the better, as it were, the stronger claim to make that. It's a good arguable case that you'll get it. Yes? So you on paragraph 26, having served your notice, you're wanting to obtain access, we say, prior to the paragraph 20 claim being heard. We say the
Because you don't know if you want. You don't know at that stage whether you want to advance.
You may not know whether you want to. That is right. But what you have to show when you arrive at the upper tribunal, asking for an interim right, pending the paragraph 20 claim, what you have to show is that you have a good arguable case that you will satisfy paragraph 21 for the making of an order under paragraph 20. So you don't have to show on a balance of probabilities that you do satisfy the paragraph 21 test at the interim stage. I would invite you, one draws the analogy to an interim injunction. I think that's the way to try and work through it. You make a claim for an interim injunction, American Sign Language is a good arguable case, well, it's a serious issue to be tried, you then have a substantive hearing. What paragraph 26 is doing is essentially saying the same thing, the same sort of procedural approach. You have a paragraph 20 claim. We say, our case is that there has to be a pending substantive claim for paragraph 20 relief. You may then make...
Can that be limited? That can be limited simply to access for the purposes of...
Well, that's what they did in this case.
No, let's say, can you have an article... Do you envisage that you can have an Article 20 claim which is simply limited to a survey of the site to see if you want to do anything further?
we would submit no. You couldn't have that.
Because you say it's not a code right.
Yeah, we say it's not a code right.
If it's a code right,
If it is a code right, then it necessarily follows that would be the case, because if
What
it's
would
a
then
code
be the,
right,
but then, right, so I'm trying to
but
understand.
but you see, for practical purposes, an operator wouldn't seek that.
Well, why do you say that?
Well, because
In those cases where, as in the present case, they simply don't know and they just want access, currently they go under 26, and all they do is they ask for the interim relief. So that indicates that all they want at that stage is that. I'm just trying to understand the practicalities of this, that's all. So that's what they do at the moment. I understand your point that if they're going under 20, they ask for everything. But there are cases, this is one of them, where they're only going to 26, so they only want one thing at the moment. So what I'm trying to understand is this. You're saying, I think you're saying is, right, if they want to make this application, they have to do it under 20. They have to have a claim under 20.
They have to have a claim under 20.
My question to you is, assuming that against you, I mean, if it's not a code right, we're now into all of this stuff
Yes.
anyway. But assuming if it is a code right, I'm trying to understand what the impact of your main submission is.
Yes.
You seem to be saying if it is a code right, they can, if they want to, restrict it. They can't, whatever they do in practice, they can restrict it as they've done under 26. But it has to be done under 20. So my question to you is, are you saying, therefore, that they have to make that application, even if it's limited to a survey? They have to make that application
If it is
under
a
20.
code right, that is one of the ways in which they could obtain access. What we say is that, in answer to the criticism that is a very cumbersome, roundabout way to obtain a site visit, that you have to make a paragraph 20 claim.
Yes.
What we say is that there are other procedures available to enable that to occur. The court has power to order that property which may be the subject matter of litigation can be inspected prior to the institution of proceedings. Section 33 of the Senior Courts Act. The Senior
Section,
Courts, Section 33 of the Senior Courts Act.
so this is before you. This is nothing to do with the code. Then.
Well,
This is applying to the High Court.
because it's not the High Court, it will be the upper tribunal, because the powers of Section 33 apply by reason of Section 25 of the Tribunals and Courts Enforcement Act 2007. So the criticism from the respondent is the very thing that your lordship is identifying, which is, well, this is nonsense, isn't it? Why?
I'm not saying it's nonsense.
Well,
I'm just trying to understand the case.
Well, this is their case. What you're saying, they say to us, is that this is just not sensible. Just doesn't seem sensible, because what you're suggesting, appellant, is that you have to make a claim under paragraph 20 for an MSV, with all that entails.
what
Yes.
does it entail? If all you want is an MSV?
Well, as I say, my lord, there are alternative procedures available.
No, just if you apply under paragraph 20, and all you're asking for is the right to carry out an MSV,
Yes.
is there a reason why that can't be summarily determined? I mean, unless you are MI5 and New Scotland Yard, then what harm is it going to do, in practical terms, to a landowner to allow some chaps with equipment onto the site to have a look at it?
When your lordship says summarily determined, is your lordship suggesting that the paragraph 20 claim is summarily
Yes.
determined, or paragraph 26?
20.
20. There is no reason why that could not occur.
But in that case, if that's correct, presumably then the test is under 21.
The test is under 21.
But if that's
That's right.
correct, then 26(3)(b), which has a different test, would never apply.
If they sought it under paragraph 20, that is right, then 26(3)(b) would not apply.
But that would make. Sorry, I'm so sorry to press this. So, I mean, the difficulty is that you're envisaging, and I think you've made this in the course of your submissions. You're envisaging that 20 is dealing with the substantive agreement. You're not thinking that 20 is only going to deal with what we describe as an interim right.
That's right.
And that's the dilemma. So what I'm putting to you, my lord's been elaborating, is a situation I don't think you're currently envisaging. You're not currently, I'm putting to you, you're not actually currently envisaging a 20 claim, a paragraph 20 claim, being limited to a site visit.
But as my Lord Justice Lewison mentioned, it is possible to have that.
It is possible, but then I'm putting to you, that seems to make a nonsense of the test in 26.3b. You seem to accept that.
I'm not sure I admitted it was a nonsense. 26 is dealing with interim.
Yes.
The point being is that ordinarily you would not wish to seek an MSV independently by itself. The starting position, we say it's not a code right at all. If it is a code right, there are alternative procedures available which were extant at the date of the coming into force of the code, which would enable an operator to obtain inspection of a property where it wanted to undertake an MSV.
And one you say is this right to inspect.
Right to inspect.
But that would be outside the code of the 2003 Act, would it? That would be an ordinary inherent power of the
He
court.
doesn't need any code protection.
No, I'm just trying to say, fine, but I'm just trying to understand the process.
Yes, that would be outside the code. That's right.
Outside the code completely.
What
was the other one?
Well, the other is that, as my Lord Justice Lewison mentioned, one could make an application under paragraph 20. It is true that that would then be subject to paragraph 21, but you're seeking it as a summary, you're seeking it determined. It's not simply by reference to the good arguable case. You're seeking it as an imposed agreement, not on an interim basis. Now, the argument against us on that is, well, why do you need that? Because that carries with it all of the rights of the code, because a code agreement is being imposed. Right. And under paragraph 26, what happens is that if you have an interim agreement imposed, it comes to an end at the date specified, and then there is no protection in relation to termination.
But if we're talking about,
Yeah.
we're talking about a survey.
We are.
We're talking about some professionals with measuring equipment, probably, being on the roof for 2 or 3 days, perhaps, looking at sightlines and all that kind of thing, and when they've done it, they go. So why should anybody be bothered about code protection after that process has been taken place, or has taken place? If you asked for the right to go and carry out a survey for a few days, and you do it, that's the end of that. And then if you think, if you like what you see, you then say, yes, we do want to install some equipment on this roof, and I will apply for the right to do it.
That assumes, of course, that it is a code right.
Yes, of course it is.
Yes.
If it's not a code right.
If it's not a code right, it doesn't apply. Now, why is anyone concerned with code protection? What we object to is the fact that a right to enter to determine suitability is itself a code right. We say we have no objection to entry by other means. That exists. That existed at the date of the code coming.
I understand.
Because the trouble is, we're not allowing you to do. The trouble is, we're not allowing you to develop your submission in the way you want, because you want to start off by saying, which I totally understand, it's not a code right. That's where you want to start from. Whereas we're rather
You
interested.
want to jump at the other end. I'm
Well,
happy
only
to do
because
that.
you're taking us through these, and that's and in a way, it's a slightly. We're trying to understand the implications of this. The other one is a matter of statutory interpretation, which is not so difficult as this one. But I still want to press you on this. I know we're taking out your order, but can I just, while we're going on this, press you on this? Where I'm left in a dilemma is this. If you do want to go for what I would describe as the full-blown thing, and you know you want to go on the site, or you think you're likely to go on the site, so you make an application under 20, you accept that you can then apply as part of that process, under 26, and in those circumstances, for the interim order, for the MSV, what I would describe as the lower test in 26.3b would apply.
That is right.
But if, on the other hand, assuming against your argument on the first point, is it a code right or not, that it is a code right, I'm trying to understand, what we're trying to understand is, why on earth would the legislature require you to make that application under paragraph 20? You're not asking for the substantive relief at the end of the day, you're just asking for this. And I think the effect of what you're saying is, in those circumstances, you have to go under 20. You can't go under 26. So you're then compelled to apply the higher standard in 21. And my query is, if that is really what you're saying, why on earth would Parliament want to make that difference? In fact, you're imposing, the effect of it is to impose a higher standard when you don't want to go for the end relief at the moment, than you would have, but you want to go for this particular MSV, a higher standard of proof than if you put in there, although you may not wish to pursue it, the full-blown thing at the end of the day and go under 26. The only consequence of that will be in every single case, presumably, people would ask for the end result even they don't really want it.
Well, a number of comments in relation to your Lordship's observations. The first is that we would submit we have to avoid being blinded by the nature of the right that was sought in this case, an MSV. It's very attractive to think that there therefore should be a easy route via paragraph 26. But what we would urge upon your Lordships is this, is that of course, if your Lordships were to uphold the upper tribunal's determination, it affects any code right that is being sought under paragraph 26, not just an MSV. So any right that is sought under the code can be made under paragraph 26 with the lower test, the lower threshold test. By way of example, in the first decision that came before the upper tribunal, in which I and Mr. Radley Gardner were involved, Praed Street, which is referred to in, I think, the Respondent's submission, that was a claim by CTIL for an interim right for 18 months. So, and it was for full rights, everything under paragraph 3. And they therefore would only have to establish for that 18-month period, for every single code right under paragraph 3, a good arguable case, without there ever being an opportunity for the site provider to turn around and say, actually, at trial, you wouldn't have met the paragraph 21 test, because at trial you would have to establish it on a balance of probabilities. The standard of proof would be different at trial. And it's right that I, the site provider, should have the opportunity of saying that code right ought never to have been imposed on an interim basis.
That turns, but that surely turns on what is meant by interim basis as a matter of statutory construction. What you seem to be saying is, in the Praed case, it wasn't interim at all. It was the final deal.
But it was made on an interim basis.
That may or may not have been correct. We're not reviewing that decision.
It's an example of, I'm trying to identify an example to your Lordships of something other than an MSV. One can be, I think, attracted by the view that 26 clearly was intended to deal with the sorts of things that is before your Lordships now, an MSV. Yeah. But what we submit is that there's a possibility that the tail wags the dog, because as it were, the peripheral rights somehow or other govern the interpretation such that the primary purpose of the right, i.e. to obtain early access, to get on, pending paragraph 20, will simply be sidestepped. Because it's not just MSVs. Paragraph 26, if it's determined that paragraph 26 can be dealt with as a substantive independent provision in its own right, that applies to any interim code right. And note, there is no limitation in paragraph 26 with respect to the period that may be sought. although paragraph 26 subparagraph 2 says for the period specified in the order, it may be a number of years.
So is it...
Praed Street was, as I say, 18 months.
Well, okay, but I understand your point to be that interim should mean here not simply limited in time, but it should be pending the full
Well,
works.
And
your complaint seems to be about the Pride case that it wasn't interim in that sense.
Well, complaint, I'm not suggesting that the complaint is not a complaint as such. I'm identifying a difficulty in upholding paragraph 26 as a substantive provision. Because if it is substantive, that is to say it's independent of paragraph 20, it enables any code right to be sought by way of paragraph 26, at the hearing of which the operator only needs to establish a good arguable case. And a good arguable case without any cross-examination of witnesses. We know that from the upper tribunal. The upper tribunal have told us this is going to be a summary form of hearing to be dealt with on documents only. Before the documents that are before the tribunal. That's all that is going to be considered. So it is also accepted that this is not a case where one has to establish the usual standard of proof. Balance of probabilities is a good arguable case. Now, yes, it looks very appealing when you're dealing with an MSV, which on the face of it doesn't appear to have any particular prejudice to the site provider, because what does it matter 13 people are going on? You can impose conditions in relation to the way in which access is allowed, supervision, etc. You can have all of that. But it's not just MSVs. It will apply to every single code right. And if it is the case, as we know, that operators claim in their notices universally every single code right contained in paragraph 3, why go under paragraph 20?
It depends what's meant
I
by
ask rhetorically.
Depends what's meant by interim.
Well,
if interim means something which is only which is pending a possible final outcome, a possible a full installation, then I'm not sure if that's what it means, and I'm not sure that your point has the same force as it otherwise would. And I thought that's how you were. I thought that's what you were saying. 26 is about. 26, you're saying, is about something which is pending.
the paragraph 20.
Paragraph 20. And you envisaged paragraph 20 to be really dealing with, at the end of the day, the full thing at the end of the day. That's the division you're making.
But let's return back to his Lord Justice Lewison's example of why cannot the MSV be dealt with on a summary basis, i.e. under paragraph 20. Well, that is true, but it provides the site provider with the protection of the paragraph 21 test on a balance of probabilities. Excuse me, my lords, I'm just going to get some water. It provides the site provider with protection of a substantive hearing at which he can test the case. Now, it may be that in a case concerning an MSV, it may be jolly difficult for him, I accept that. But it gives him the protection that paragraph 26 doesn't. Now, it also may be that what the site provider does is to say, well, I'm serving my paragraph 20 for the MSV, but at the same time, I'm asking for paragraph 26. All I want to do is to get on. And again, he only then has to meet the good arguable case threshold, but it still then protects the site provider, because the site provider says, yes, actually, you have established a good arguable case, but in fact, when we get to trial, that would never to have been imposed. Now, that protection to the site provider is lost if one upholds paragraph 26 as a substantive provision in its own right.
Do any of the later paragraphs on your list shed any light on this?
There is the contrast that's made by the respondent with paragraph 27, which I think has been touched upon. The only other paragraph that not on this particular issue, my lord, no, just to draw your attention, was 30 subparagraph 3.
Can I just
Sorry, Mark.
ask you this, Mr. Stark? drawn an analogy with an interim judge,
Yes.
the price of which, of course, is a cross-undertaking and damages.
Yes.
Suppose that you get an interim right under paragraph 26 on the basis of good arguable case, but then fail under paragraph 20 when it comes to deciding the test
Yes.
on the balance of probability. Now we know from paragraph 26 subsection 8, subparagraph 8, that we can be required to remove your kit.
Yes.
But what about compensation?
Well, the compensation, paragraph 26 applies paragraph 25, payment of compensation, paragraph 4, 26.4e,
Right, we'll accept it.
and then paragraph 25 refers to compensation
But that's
in relation to the exercise of the code right.
Sorry, 26.4e.
26.4b,
E, B,
E,
E.
my lord.
Oh, I
E.
see.
And that applies 20,
Yeah.
that applies 25.
so ex post facto you can go back to the tribunal and say, well, the application under paragraph 20 is now failed, they've been on my
Yes.
list for a year or whatever it is.
Yes, and then that is, as it were, picked up by 25 subparagraph 2b at any time afterwards.
Right. Anyway, you.
Sorry.
Sorry to have interrupted.
No. That was a canter through the code.
That's been helpful, thank you.
Those are the provisions I think that we may, I'm sure we'll come back to. So, unless there are any other particular parts of the code that the Lordships want me to deal with now, I'll move on if I may. So, as a preliminary, the first point is a point I've already made, which is, just to reiterate it, the code right relates to land. Code, and it's any land. There's no dispensation to that. Therefore, the operator can identify any land it likes, decide that it wants to go and have a look, and then exercise its right, if it is a code right, to come off. The second point is that, and we've touched on this earlier, which is, it is said against us that what we are asserting puts the site provider into a ransom position. It enables the site provider to ransom the operator, because if it's not a code right, the only way in which it is said the operator can enter the site to undertake its MSV is at or by agreement with the site provider, and the site provider is going to ask for a lot of money. We say that's not right, because one, there are the alternative procedures which I have referred to, section 33 and section 25 of the 2007 Act. 33 Casino Courts Act 25 was 2007 Act. And secondly, there is the possibility of obtaining the right in the manner that I've mentioned, which is you make your claim under paragraph 20, seek an immediate paragraph 26, or even seek, as a term, paragraph 23 could impose a right of inspection to give effect to the code right sought. If your Lordships recall, paragraph 23, subparagraph 1 referred to terms to give effect to the code right sought. And that would encompass a right to go on to inspect.
How is that?
I'm sorry, my lord?
Just explain how that works. The operator applies for the right to install electronic communications apparatus on the roof. And as an adjunct to that, though not a code right, you say, the terms will include the right to go and carry out the MSB. In imposing that agreement, the court is required to provide for consideration.
Yes.
So what does it do about consideration for the installation of the equipment which the operator hasn't yet decided whether it wishes to install.
The
And doesn't know if it is going to install anything, what it's going to install. There might be weight problems, size problems.
yes. Yes. Paragraph 24, subparagraph 4. Which one should have that? Provides that the terms of the agreement may provide for consideration to be payable either by a lump sum or periodically on the occurrence of a specified event, or in some other form, or at some other time or times as the court may direct. So that appears to enable the tribunal to make an order with respect to consideration when ECA is then installed. Those were just a couple of preliminary points. May I, therefore, deal with the first issue, which isn't a code right at all? We shall, of course, return to the question of it being parasitic, so I'm not abandoning that in any way. But let's just deal with the issue first. Is it a code right at all? Now, one needs, obviously, to start with paragraph 3. And a number of points may be made with respect to it, which is that it is a menu of rights. The fact that the operator has one item on the list does not provide the operator with any other. So a right, for instance, to keep equipment on land does not give the operator the right to enter the land to inspect or repair it. They're independent code rights, a menu of rights. It is interesting to note that only one of those 9 rights refers to a right of entry, paragraph F. It is to enter the land to inspect. But that is in relation to ECA, which is on, under or over the land or elsewhere. We do not, it is to be noted, if one undertakes a search of the code, one does not find a single reference to the word survey, a single reference to the word suitable. One finds reference to the verb to enter only 6 times in the code, only 3 of which are contained within what one refers to as the general regime, parts 1 to 6 of the code. The other references are contained in the special regime. The references that one finds to the verb to enter are 3F, 16 subparagraph 2, and 34 subparagraph 6.
What was the first of those?
I'm sorry, my lord. Repeat
16,
those.
2 and 34.
Yes, I apologise. 3 subparagraph F, 16 subparagraph 2, and 34 subparagraph 6.
34.
Subparagraph 6, my lord.
Don't think we've got paragraph 16 in the next one.
No, my lord, apologies for that. I am sorry.
34.
16 is to do with the right to assign,
Yeah.
and 34 should be in the bundle, my lord, which is to do with orders that the tribunal can make on a Part 5 application.
Well, that's entering into an agreement.
That is entering into agreement. All I'm saying is that the verb to enter is only found 3 times in relation to when the draftsman wanted to refer to a right to enter. In fact, we only find it in subparagraph F. Now, one may ask rhetorically, why is it that the right to determine suitability is not referred to? Why isn't it there? Why isn't it found in the code? Well, there are a number of reasons we say why that is. The first is that there appears to be a complete lack of parliamentary debate with respect to any detailed consideration of the code. And it may be that that lack of debate could be consistent. It's an indicator that Parliament considered that they were to maintain the status quo with respect to rights of entry to determine suitability. Second, it may be considered that the absence is deliberate because of the fact that it was considered that the status quo was sufficient, and of course a provision for entry to determine suitability could have been more clearly signalled if Parliament had intended that right to be conferred on an operator. It would have been simple to say so. And part of that context of maintaining the status quo is that we submit that it was envisaged, because of the various circumstances with respect, differing circumstances with respect to operators, the site providers, and the terms that would be sought, that it was going to be left to agreement between the parties. We say that that is reflected in the Law Commission report that was a prelude to the new code coming into force. If your lordships would be so kind to look at bundle 2 of the authorities, tab 29, please.
We'll be slightly careful about Law Commission reports because while they may be a useful source of background material, where the Act has been changed in course against this Parliament.
So I've got tab 29, I do apologise. Tab 26, thank you. Apologies, tab 26.
You've got to be slightly careful. This was a case, was it, where there wasn't a bill drafted?
There was not a bill drafted. But if your lordships turn to tab 26, this is an extract from the Law Commission, and there was a discussion about ancillary rights. Does your lordship?
Which page?
It's the first page, page 55 at the bottom of the extract. And I'm referring to 3.66 to 3.69. 3.66 is a comment by a firm of solicitors during the consultation process about rights of entry. And it said that right to enter land to access, that's apparatus, cannot be dealt with by way of unrestricted right. Many wireless cell sites are located on land owned by statutory undertakers. They are obliged by their own governing statutes to restrict access to their land for security reasons if unrestricted access rights are imposed. These companies are likely to withdraw their land from the sector, which will lead to a hindrance to the provision of communication services. The same applies for rooftop sites located on buildings occupied by sensitive occupiers, governmental organisations or financial institutions. The most appropriate place to deal with access rights is the written agreement. Each party has an opportunity to set out the exact access procedure. The agreement is also the proper starting point to resolve any difficulties arising from obtaining access. 367. We agree. The difficulty encountered by all the suggestions for ancillary rights is the impossibility of catering in the revised code for the precise rights required. It is not practicable to specify the details of access, even in emergencies, without having the details of the site itself, and what is appropriate for a mast site serving half a town may be wholly inappropriate for a cable serving a single property. The more complex the site, the more complex the rights required, and indeed the more sophisticated and able to negotiate the site provider is likely to be. infrastructure providers are inevitably the most sophisticated site providers. They offer an impressive range of services and well aware of the code operator's need for security, access, power and other facilities.
But this is all concerned with access to installed apparatus.
It is, but it reflects, it resonates a concern that we say is one of the reasons why there is no express right and why there should be none implied, is that it resonates with the concern about the difficulty of identifying the precise right that you require. And when the code, sorry,
as my Lord Justice Arnold points out, this is about ancillary rights of access to access apparatus. And there is such a right. It's exactly 3F that you took us to. There is a right to enter the land to inspect, not buildings, apparatus.
yes.
So although the Law Commission agreed with the difficulty of defining such a right, nonetheless such a right is a code right.
Well,
Is it not?
obviously, what the court was concerned with, or sorry, what the tribunal, the commission was concerned with, was the question of ancillary rights with respect to the access. I'm referring to the passage, or passages, to identify a concern with respect to ancillary rights to access the ECA. We say that that resonates with the general concern about being able to provide a list of ancillary rights. Clearly, a right to undertake an MSV cannot be said to be within the express terms. It doesn't say enter to determine suitability.
What I'm putting to you is that insofar as the Law Commission agreed with what Shoesmiths had said, and said it all must be left to negotiation, Parliament seems to have taken a different view because of the inclusion of the code right in paragraph 3F, which is exactly the sort of right that Shoesmiths were talking about.
Well, my lord, 3F is is actually identified specifically in the Law Commission report as a right that was to be included. I don't have that particular passage here. I shall endeavour to obtain that over a lunch adjournment. But F is an express right to enter with respect to equipment that is already on the land.
Yes, well, isn't that what Shoesmiths is talking about?
Yes, but
Rights to enter land to access apparatus.
and the concern is about further additional rights. So rather than have an extensive list of additional rights that may be provided for when you obtain your code right, that was to be dealt with by way of an express term to enable the tribunal to impose such other terms to give effect to the code right sought. We see that in paragraph 23.
Is there something in the Law Commission's report about suitability itself?
So Lord, at
About suitability itself, is there anything in the
no,
report?
there isn't. No.
Right. That suggests that the Law Commission simply overlooked the matter.
Well, with respect, the answer to that is we submit no, because, of course, part of the background material are the pre-existing legislative provisions that existed at the date of the code coming into force. There is an express statutory provision to enter land to determine suitability for the purposes of a network. That remains and was contained in and remains in the Communications Act. Schedule 4, that is contained in the separate additional bundle of authorities, tab 1, my lords.
That's as a precursor to compulsory purchases, is it?
Well, that is what it is said by the respondent. We submit, looking at it, it is not the case that it is clearly intended to be limited. The right of entry is not on its face limited to facilitating acquisition by way of compulsory acquisition. It doesn't say that. This,
What are we supposed to be looking at?
Well, your lordship is looking at paragraph 6, entry
Yes.
entry on land for exploratory purposes. This is a provision of long standing because it was contained in section 37 of the Telecommunications Act 1984.
All right, can I just distinguish between two different purposes for which you're using this? I understand the argument you say, well, there are pre-existing provisions and therefore there's not a problem. I understand that argument. But I thought we were talking about the Law Commission report. Is there any discussion of this provision in the Law Commission's report?
But there is no discussion of this provision in the Law Commission's report.
So why does this help to show that the Law Commission didn't overlook the matter of suitability?
In terms of access, clearly they considered access, and in terms of a specific reference to entry for suitability, the only information I have been able to find with respect to what was before the Law Commission is that contained within the consultation report. I referred the Deputy President to that. It is, I think, referred to in his judgment. May I just refer to the decision of the Deputy President, which is going back to the core bundle. If your Lordships turn to page 73 of the core bundle, paragraph 70, the learned judge, in dealing with this argument, I had before the learned judge the consultation, the responses, 130 of them, to the consultation. And the argument is picked up in 69, where I've referred to paragraph 6. Paragraph 70, as Mr. Clark demonstrated, it cannot be suggested that the code was drafted in ignorance of the normal requirement for preliminary surveys, or of the potential for them to cause delays. He referred me to the consultation on the Royal Commission's proposal, in which one consultee, Cable and Wireless, had drawn attention to the need for site surveys and to the difficulty of obtaining prompt access for them without operators being held to ransom. The consultee suggested that the right to survey was implicit, but requested that a standalone right be provided for. Another consultee, Mobile Operators Association, also suggested the old code was deficient in failing to provide for such a right. So, in answering your Lordship's question, the Law Commission were aware specifically of the question of access to consider the issue.
As I understand what you've said, notwithstanding these points being made in the consultation responses, they were not addressed in the final report.
They were not addressed in the final report, in the sense also that they were not identified, or the right to determine suitability was not identified as a specific code right in the suggested menu from the Law Commission. I shall provide your Lordships with that this afternoon.
Is the consultation referred to in paragraph 70? The consultation between the Law Commission's own preliminary work and its final report, or the second round of consultation, which Mr. Vasey announced or referred to in the ministerial statement? He said there had been further consultation after the Law Commission's report before the government decided what to do about it. Which consultation is this?
I believe it is only the first, that is the Law Commission's own internal. I believe that.
Before the Law Commission's final report?
Yes, before the Law Commission's final report. And just to pick up on what your Lordship has just said, in relation to the DCMS, the response to that, it is also worth just looking at that, because that is to be found in tab 27 of the bundle of authorities. As my Lord Justice Lewison mentioned, there was then a further consideration by the Department of Culture, Media and Sport. And we see that there is an executive summary commencing at paragraph 5. Sorry, I do apologise, Molly. Yes, page 5, thank you. And then page 7. We have 2 points that are essentially made. One that we'll come back to about the nature of interim rights, but then the other is talking about access. We have what is said here: to promote greater efficiency, the new code will contain provision that allow fast interim access to the sites for communications providers in appropriate circumstances. This will enable providers to access sites more quickly, even while valuation is still being resolved. Government does, however, have a clear policy to only introduce new powers of entry in exceptional circumstances. Having reviewed the evidence very carefully, it was decided that at present, criminal penalties for denial of access and associated stronger powers of entry are not warranted. Now, that's the best one can do when one researches the background material. But that is a strong indication, we say, from the government that a new power of entry was only going to be provided for in exceptional circumstances, and it was considered that associated stronger powers of entry were not warranted. Now, as with many things, one has to take a step back and look at the body of evidence that we have. We have the consultation references to which I've referred in the judgment of the Deputy President. We have, that expresses a concern. We have the Law Commission, yes, albeit in relation to access, identifying that access to ECA, that one cannot come up with a lengthy list. We have the DCMS making express reference to rights of entry and not providing for associated stronger powers. And then we have the code. The code does not provide for an express right of entry to determine suitability. That was a matter that was in the mind, we submit, of the Law Commission, having regard to the material to which I've referred. They did not make provision for that by way of an additional code right. We submit that that is a powerful indication that there was not intended to be provision for determining suitability. My Lord, sorry, we went off.
Consultation described in paragraph 9 of this document, and with a wonderful title, Stakeholder Engagement. That's all post-Law Commission.
Yes, I believe that is so, my Lord, because
Yes, is that not what's being described in paragraph 5? They talk about the government's consultation from 2015,
which is
February
post the report.
Yes, and they say in 6 that builds on
Yes,
the Law Commission's extensive public consultation in 2010, 12, 13.
Which page are we looking at now?
Pages 8 and 9, my Lord. Bottom of page 8, paragraph 5.
Oh, I see.
And that
And then
is
6.
draft list
And then
of
6.
explanatory notes.
Yeah. Yeah. Yes, my Lord, we went off on a slight tangent. I believe I hadn't answered the question from my Lord Justice Lewison about the reference that you made when we were looking at paragraph 6 of Schedule 4 to the fact that it was limited to compulsory acquisition. That is how the Deputy President saw it. I submit that it is not so limited. In a sense, it matters not, because it is the principal point to take from it is that it's a piece of legislation which pre-existed the coming into the force of the code, with which Parliament is taken, or it is assumed that Parliament is aware of the pre-existing law.
So can I just ask, what were the criminal penalties for denial of access?
I assume that it was proposed that there would be some form of financial penalty if you did not provide access to the operator.
Is it present criminal penalties?
I'm not sure
what were the
what those
present
are.
criminal
I'm not
penalties?
sure what those are, there is a proposal at the moment in relation to access with respect to premises where the occupier is seeking the provision of a network service to the building itself. There's a new proposal.
No, but I'm only concerned with what he was referring to. He
I'm
trying to understand what he was getting at.
I think it says at present, they're not warranted.
Yes, at present criminal
I see.
penalties. Yes, at present. So there are no criminal penalties. The suggestion is there ought to be, and then the conclusion is at present there are not going to be any. And equally, there are not going to be associated stronger powers of entry. They're not warranted at the moment.
It's a classic government statement saying we're not satisfied that action is warranted now, but we're leaving the door open if these measures prove to be insufficient.
And as I say, that there is a piece of legislation moving through Parliament, subject obviously to the election, but there is a piece of legislation with respect to greater powers of entry for those that wish to have a network service provided to their premises. It's a very specific piece of legislation, but it is dealing with rights of entry and criminal sanctions.
I'm just trying to understand this paragraph 5, the 15 then.
Sorry, my Lord, the Lord is looking at paragraph 15.
Of the introduction.
Yeah, the executive summary, yes.
To promote greater efficiency, the new code will also contain provisions that allow fast internet access to sites. So, accepting that there will be, allow that, this will enable operators to access sites more quickly, even while valuation is still being resolved. It doesn't say what those are, he says they are some. They're in the code.
Yes, that's what...
Government does, however, clear policy, and so he's saying that those which are in the new code are sufficient. What I'm trying to understand is why you get out of that the proposition that there weren't to be any specifically mentioned. Why do you get that out of that?
I have placed reference upon and associated stronger powers of entry.
Yes, he said, well, having reviewed it, it was decided that at present criminal penalties for direct and associated stronger, presumably associated with, I don't know, with those penalties, stronger powers of entry are not warranted. That is stronger, presumably, than are presently provided in the code, which he doesn't specify.
Well, he doesn't specify. When one refers to the powers, it may be that the powers are those that we were considering, i.e. paragraph 6 of Schedule 4.
I don't know. I will try to understand. Why do you say that this paragraph evidences that the government did not intend to impose under the new code any provision for access? I mean, it would seem it's the contrary that it says in the first sentence.
That is interim access, not powers of entry. A power of entry.
Interim access is entry.
That's one way of interpreting it. We're not interpreting a statute. We're trying to extract guidance as to the thinking of government. Given that we know that the Law Commission had before them, via the consultation that they had, a concern about a right of entry to survey, given that they did not make an express right within their recommendations as to the rights that one finds in paragraph 3, and given that the background is that there are provisions relating to entry for suitability under paragraph 6 of Schedule 4, when this document is referring to rights of entry, powers of entry, in exceptional circumstances, and associated stronger powers of entry, there are no additional powers other than those that have been provided for.
What we have to ascertain is not the intention of the government, but the intention
I
of Parliament.
accept that, my lord.
So in ascertaining the intention of Parliament, we look to the words of the code as enacted, the Law Commission report as a source of interpretative guidance is useless because it doesn't address this issue. Why is this document from the DCMS any better? Because it doesn't address it either.
Well, your lordship is concluding that subparagraph 15 is not making reference to it. it is clearly making, the juxtaposition is between interim access with evaluation being resolved later.
But the key point you raised earlier, rightly, as it seems to be at the moment, is were the minds of those involved in the legislative process addressed to the question of suitability? And when we look at the Law Commission, we get a blank.
Well, not
When
quite-
we look at
not
this,
quite
we get a
that,
blank.
with respect, my lord. There was a consultation which gave rise to concern about a right to access to
But as
survey.
you accept it,
no,
not addressed by the Commission in its
not
report.
addressed, but they did then make provision for identifying what the new, more extensive menu of code rights were to be, and they did not make provision for a right of entry to determine suitability. That must carry some weight.
But there's nothing in the report that helps us as to whether they didn't do that either because they considered what was put forward in the consultation by those responding and rejected it, or because even though the points were made in the consultation, they ignored it, or they thought that it was already covered. We just don't know.
We don't know. One can, of course, infer that given the fact that it was something that was raised before them as a concern, and given the fact that they then identified 9, actually they identified less than 9, the lopping of trees came later, but the fact that they identified a limited number of rights which did not include a right to survey, the fair inference to draw is that it was a deliberate decision not to add to that right. And also, one obviously has to have regard with respect to ascertaining Parliament's intention, or the meaning of the words, that there is this right in paragraph 6, schedule 4, which does expressly refer to a right to determine suitability. If we could just go back to that for a moment, in tab 1 of the additional bundle. The additional bundle, a slimmer version, my lord, with a... yes. Do your lordships have that? It's
The call bundle.
it's tab 1, not the supplementary bundle of authorities, my lord.
You've got 2 supplementary ones. Yes. Okay.
I'm sorry, of authorities.
Right.
It's I think has a red
Yes.
colour down the spine.
Yes.
So, paragraph 6, entry on land for exploratory purposes, says a person nominated by a code operator and duly authorised in writing by the Secretary of State may at any reasonable time enter upon and survey land in England and Wales for the purpose of ascertaining whether the land will be suitable for use by the code operator for or in connection with the establishment or running of the operator's network. You could not have plainer language than that. That was, as I say, pre-existing Section 37 Telecommunications Act 1984, pre-existing the coming into force of the code. This is contained in Schedule 4 of the Communications Act 2003. The code was put into Schedule 3A of the Communications Act 2003. So this is the very next schedule.
Doesn't apply to land covered by buildings.
It doesn't apply to land covered by buildings. So that is one of the reasons why the operator cannot utilise this. We say it's not limited. If one looks at limited to compulsory purchase, it doesn't say that in paragraph 6, nor does it say that in the substantive provision of section 118 of the Communications Act, which refers to this. If we just look at that a moment. That is also in tab 2 of the authorities bundle. It is tab 17 moment. And looking at the page numbering.
So which
I'm sorry,
bundle are we in?
Volume 2 of the bundle of authorities.
Yes.
Section?
Section 118, my lord. This is
Which tab?
it is tab 17, my lord, and the page top right hand corner is 187, right. Apologies, it's not easily marked, but it's section 118. Do you have that, my lord? Thank you. You will see it says Schedule 4, which provides for compulsory acquisition of land by the provider of an electronic communication network, in whose case the Electronic Communication Code applies, and for entry on land by persons nominated, shall have effect. It doesn't state that it's limited to compulsory acquisition. And
So I think your point here really is at least twofold. One is that it's not as difficult to draft as the Law Commission thought it might be. Here is one.
here is one.
Here's one I made earlier.
Here's one I made earlier, absolutely. And it's spot on. It's the very words that one would want to use.
The fact that it's not incorporated in the code, which is in the very same act as this provision, shows that the omission was a deliberate one. Even though this particular right doesn't apply to land covered by buildings, there wouldn't have been any particular reason not to exclude that exclusion.
Well,
That's what was intended.
that is what we say, and there's of course a paradox in the respondent's position. The paradox is that the less one says, the greater the rights that are available to you. That's the effect of their contention, their submission. Because nothing is said, you have the greatest possible extent of rights available. My lords, apologies for...
118 is headed compulsory acquisition of land, etc.
etc.
It's true.
And
I maybe said that what it's plainly looking at is where there's a provider of an electronic communications network who is interested in compulsory acquiring land and for that purpose providing for entry on it. Very, very odd if you're going to have, if you're saying this is the substantive provision covering all cases in the code for entry by persons provider of electronic communication network to be hidden away under that title and then turning to the actual provision itself, that part of the code heading compulsory purchase of land.
yes. But
I mean, it says entry on land for exploratory purposes, but that's plainly for the purposes, is it not, of
the whole
compulsory
of this,
purchase.
section 118 forms part of Part 2, Chapter 1 of the 2003 Act, which is headed Electronic Communications Networks and Services. That's the heading.
I thought your point was that it didn't matter that this was defined in the passing purchase or not.
That is so.
The point is, here is an example of
Yes.
a piece of parliamentary drafting which achieves the objective that Cornerstone wants, apart from the exclusion of land covered by buildings, which could have been adapted for the purposes of the code and wasn't.
Yes. That is so, my lord, and there may be a reason as to why it was thought the status quo, as I've described it, was considered sufficient. May I, and apologies, it feels like confetti being thrown at your lordships, but just a further case, if I may, from the upper tribunal, one short paragraph, if I may. This is the decision of E.E. Hutchinson 3G, decided this year by the upper tribunal. May I just refer your lordships to paragraph 2? In May, does your lordship have that? This in fact was a case where there was a paragraph 26 determination followed by this decision, which is the full-blown para 20. Paragraph 2, it states, in May 2006, the government published an impact assessment on the anticipated effect of the introduction of the code. It stated that in 2015 there were around 33,000 telecommunication sites in the UK which attracted a rent, of which about 22,000 were let or licensed directly to mobile network operators, the remainder being let to wholesale providers. Of the operator site, 18,200 were greenfield, 4,000 were rooftop. It was estimated that operators paid, etc. So, What is interesting about that is that it suggests that the study indicated that the majority, overwhelming majority of sites were properties where there were no buildings. There's only 4,000 rooftop sites. It's a modicum of support to suggest that the right that we find in paragraph 6, schedule 4, was considered satisfactory. My Lords, if I may move on to the actual paragraphs which the upper tribunal decided the right to determine suitability came within. We had paragraph 3.1a and paragraph 3.1d. 3.1a is the right to install, and the upper tribunal said that this is, as it were, a sort of stepping stone to installation, and that it was part of the right to install. We submit that the wording is ill-suited to cover a determination of suitability. True it is that install is not a word of art, but its indefiniteness, we say, gives it a sort of chameleon-like character. Associate words show the colour and meaning of it. And we see that from the other paragraphs, 3c and f. Because 3c, we see the right to inspect. And note 3f, to enter and to inspect. We submit that the right to install, the meaning of install, does not enable one to extend it to a right to look. That's essentially what this is, because it's a non-invasive survey that's being undertaken or proposed, or was undertaken. It's non-invasive.
Well, I think your point really is that if it turns out, as a result of the MSV, that the site is not suitable, so that no electronic communications apparatus is ever installed, how can that process be part of installation?
That is absolutely right, my Lord. That's what we say. All that the MSV is doing is facilitating a formulation in the mind of the operator. It's nothing to do with installation. As your Lordship says, how can you say that it's a right to install when it may be decided upon view you're not going to install at all? And the synonyms of install militate against the right being within a. I mean, the synonyms of install are building in, fit, fix, introduce, lay, place, station, site. All of those synonyms indicate that you're not dealing with a right to look. So the matter cannot be elaborated upon. It's a matter of impression more than anything. So I would move on, if I may, to the second, the works. The second approach taken by the tribunal was that it came expressly within 3.1d. We submit that this is intended to be limited to physical work, and the Deputy President accepted that as a matter of ordinary English. if we turn back to the
But
judgment,
the adjective physical is notably absent, so why should we read it in?
because that is, as a matter of ordinary English, what works would ordinarily suggest in the mind.
Depends on the context, isn't it?
Depends on the
Well,
context.
this is William Shakespeare.
That is true. But of course, the context here is dealing with the installation of electronic communications apparatus. It's to do with works of maintenance, adjustment, alteration, repair, upgrading, or operation of ECA. Sorry, apologies, that's E. To carry out works on the land for and in connection with the installation of ECA on, under, or over the land or elsewhere. It's the installation of a piece of apparatus. And we know that apparatus is dealing with a physical structure because that's the definition of apparatus. We see that in subparagraph 5. The definition of apparatus tells us what apparatus is. So
To be sure, so apparatus is something physical, but why does that compel the conclusion that works have to be physical?
because it's for in connection with the installation. The works have to have an association with what is being undertaken. You obviously have to have regard to what it is you're trying to achieve. What you're trying to achieve is installation.
Suppose I'm measuring the rooftop to see if the physical equipment will fit into the space. Why is that not a work?
It is not work that involves any form of invasive work to the
So you're
property.
now reading in the word invasive.
I'm reading it as physical work. The question of physical work in terms of what it is we say obviously relates to the sort of work. Let's step back. The work is in connection with, in connection with installation of ECA. We know ECA is a physical piece of apparatus. We know that. So the suggestion that works is not going to be anything other than some form of work which requires an element of attachment or some form of invasive procedure, we submit isn't intended to be encompassed by works.
So if I want to put a ladder up, is that within or without the right?
Well, the ladder is to presumably be able to observe something. The ladder we would submit. If simply, again, it depends on the context and it depends on the purpose. One is not, when you put the ladder up, proposing to install the ECA. It is simply for the purpose, presumably, of observing whether or not the whatever it is you're looking at will be suitable for ECA. We say that the ladder, the erection of a ladder is not work.
Are you really saying that if you need to go on to a building in order to carry out a detailed survey for electronics and other purposes, in order to make sure that the structure you're going to erect will fit, will operate properly, that part of it does not fall within D? Is that what you're really saying?
Well, your Lordship is expanding what we're saying. Your Lordship mentioned not is structurally sound. This is a non-invasive survey. There's no suggestion that one is undertaking, for instance, the taking of a core of the roof to determine whether or not the structural integrity.
Even so, whether you take the weight, whether the size.
Well, how does one
go there?
I ask rhetorically, how does one ascertain that?
You get,
By simply walking on the roof doesn't enable you to ascertain anything
you
about
have
its
to take
structural
measurements.
integrity.
You have to do all sorts
Well,
of
measurements
things.
simply.
And then you draw up plans.
All it does is enable you to identify the approximate location of where you want the ECA. It doesn't do
Suppose I
anything
take
else.
some ultrasound equipment onto the roof. What
Yes.
about that?
Yes, I thought of that. That is a possibility. You could measure without a physical tape. That is true. That may be encompassed in the MSV.
So,
I mean,
so
what-
is ultrasound covered or not
Well,
on your submission?
I would still submit it's not work. It's not work in connection with installation. It's work in connection with facilitating the decision as to whether or not you wish to
There
install.
are 2 points that you're conflating. One is whether these things are works at all, and the other is, if they are they within the specified category of works? Now, can I go back to an example that you gave to my Lord the Master of Rolls? What if the MSV does require a course sample? So you actually drill a hole in the roof and take out a bit of concrete. Do you accept that as works?
If it required invasive work, then that would be work. I would accept that. I would accept that.
The question would then be, is that in connection or in connection with the installation of electronic communications apparatus?
And if it transpires it is not to be installed, then the answer is no, because why you are performing it is that you are performing it because you wish to facilitate in your own mind the decision as to whether or not you wish to install it. It is, as it were, to use language of Lord Asquith in Cunliffe and Goodman, you are moving from the zone of contemplation into the valley of decision. It facilitates a state of mind, not installation of ECA. I was trying to think of an example, and as I thought of it, I might as well use it, but it may or may not serve my purpose. Let us think of installing a lock on a door. I'm not replacing the lock, I'm going to install the lock on a door. So I go to view the door, because that's the MSV, I'm looking at it. Looking at the door enables me simply to know whether it's painted, enables me to identify the approximate location as to where I wish to put the lock. What it doesn't enable me to do is to know whether or not the door is suitable for the lock, because without undertaking some form of invasive survey, I wouldn't be able to know whether the location that I've identified by the view is suitable, because it may be hollow, not solid wood. Looking doesn't facilitate installation, it's not work of installation. Looking at the door cannot be described as work. One can only say this in so many ways. We submit not within the statutory provision. There is an authority which my learned friend was proposing to refer to, and if I may refer to that in relation to work, it's contained.
Spencer.
It is Marks and Spencer, my lord. Yes, thank you. It's contained in the supplementary bundle. It is tab 3 of that bundle with the red stripe down the spine. And this was to do with the question of whether or not building work had begun for the purposes of the implementation of a planning. And what had happened was that there had been demolition, but not the actual commencement of the new building. And the relevant passage I would wish to refer to is in the judgment of Lord Justice Jenkins at page 564. He says on that page, in fact, we just go over the page because he makes a conclusion about what the judge reached as irresistible. Just the last sentence at the bottom of the previous page. For my part, I find irresistible the conclusion reached by the judge as to the meaning of these words when he said it is clear that the erection of a building need not have been begun, because otherwise no meaning would have been given to the words works for. It is therefore, in my view, not necessary in order to bring a case within the subsection that one should be able to point to some work of construction. As I say, they'd only demolish, and say that is part of the new building, the erection of which has been begun. It is enough if, on the facts, one can conclude that on the site in question, operations have been carried out which are part of the totality of operations necessary on that site for the purpose of carrying to completion a particular building project. Where it is shown by the evidence that a building owner had in view a particular building project to be carried out on a site already built upon, and that his intention to carry out that project had never been abandoned, then work such as the demolition of the buildings already on the site as a necessary preliminary to the carrying out of the building project would, in my judgment, be works for the erection or alteration of a building. Of course, where the works are of such a nature that in themselves they might or might not be works which were being carried out for the purpose of executing some particular building project, it may well be that the onus is then on the building owner to show clearly that his intention from the outset had been to carry out some particular building project through to a finish. Obviously, where a man had started putting down a house with no more than a general intention of erecting something, he could not come within the subsection. So, by analogy, the MSV, not only does it not tell us whether or not there is a specific ECA intention, i.e. an intention to install ECA, but it doesn't even tell us what ECA is going to be installed. It is the, as it were, general notion of something, as referred to by Lord Justice Jenkins. And we submit, therefore, it doesn't fall within the wording. We say that that case, in fact, supports us.
This is on the question for or in connection with.
For in connection with, yes, my lords. Yes, thank you, yes. Coming back to the dichotomy which your lordship drew.
Just on the question, the other question that arises under this head, what is the meaning of works? Passage of page 572, first and fifth paragraph on the page with Justice Morris.
572, my lord.
572, first complete paragraph on the page,
Yes.
in the absence of any definition, that paragraph.
Yes. Well, that is the passage, as I understand it, upon which the respondent is proposing to rely. But as he says, he's not attempting to define the word.
It all depends on the
It
context.
depends on the context. I fully accept that. And that is why I say the context here is in relation to a physical piece of apparatus.
Can I
ECA, you see that.
I was asking this question getting back a little bit
Yes.
on the consultation of the government's proposals and so on. Your case is that it was well established that a right of entry by a telecoms operator to install ECA under the old code was restricted to open land and not to buildings.
Yes. Section 37 of the...
You're saying that was common knowledge and that was
Yes.
limitation.
Well, it was since 1984, Section 37. Then the 2003 Act, Schedule 4, Paragraph 6. Then we have the code. And the code comes in at Schedule 3A, and the right of entry is contained in Schedule 4.
Sorry, was my statement incorrect? That your case is that certainly up until the new code, it was accepted and understood that entry was for anything other than buildings. Is that not your case?
That is the position we submit. Yes.
That was my start.
Yes. Sorry.
That's right. And then I wanted to say to you, was there at no stage any representation by anyone that was too restrictive?
The only evidence I was able to find was looking at 130 responses to the consultation, and the evidence is contained in paragraph 70 of the Deputy President's judgment.
That's Cable and Wireless.
That is Cable and Wireless and Mobile Operators Association.
So nobody raised that issue, you're saying?
Well, they raised it in an indirect way, saying that there was a problem with an entry to survey. One thought it was implicit, the other thought that...
So the point was raised.
The point was raised, my lord. If we could turn back to that, just so your lordship is aware of that. If we turn back to paragraph 70 of the judgment, page 73 of the core bundle, tab 5.
Sorry, I've taken out my copy of the judgment.
Yes, so paragraph 70 of the judgment, there is this reference to evidence in the consultation paper to the Law Commission, and there's a reference there to cable and wireless, a need for site surveys, and the difficulty of obtaining prompt access for them, that is site surveys. And then there was a suggestion, it was implicit, but requested a standalone right. Another consultee said the code was deficient in failing to provide for such a right. So it was raised by two, obviously very substantial bodies with respect to that. And for fear of treading on the pushback to the Law Commission, even more so when one refers to a consultation paper, may I just refer your Lordships to tab 25. Tab 25. If your Lordships have that, page 18, paragraph 3.8, starts off with what can be agreed.
Page 18.
Page 18 at the bottom, my Lord.
Yes.
Paragraph 3.9, principal code rights, and then they are set out.
No, I haven't
Sorry, where are you?
got that.
I might, apologies, my Lord.
Tab 25.
Tab 25,
I've got 3.7.
yes, and then 3.8.
Yeah.
At the bottom of the page, there's a page 18. Apologies, internal pagination.
Page 41.
Ah. Do you have, is your heading at 3.8, rights and obligations within a revised code?
No,
Ah.
mine's 3.8. Start we are in consultation.
That is tab 25 of the second bundle, my Lord.
Oh, what?
Second bundle of authorities, tab 25, sorry.
45.
25, my Lord, 25. 2
It
5.
says it is.
Ah,
Yeah.
yes, they're sequential.
I've got two pages. One is the Law Commission Electronic Communications Code, Law Com 336, and the other is paragraphs 3.7.
That's tab 26 in mine.
Ah, it may have. The consultation paper in my Lord Justice Arnold's is 26.
It's the previous tab.
Ah,
So I have it where you have it.
yes.
In 25.
Thank you.
So,
Has it just been transposed, my Lord? Is it
what am I looking at?
at the consultation paper, number 205 of the Law Commission? The index, I believe, does refer to it as tab 25. Apologies, my Lord, I can come back to that.
My 25 is Law Com 336, as is my 26.
Then there's been an error there, my Lord. I'll come back to that, sorry. Let's move
Can
on.
you just, which was the paragraph you're going to refer to as a matter of interest?
It was paragraph 3.9, which identifies the old code rights, and then 3.10, which simply said the focus of these rights is on physical works and the maintenance of electronic communications apparatus on land for the provision of the code operation network. So that's how they viewed those old code rights, which, when one looks at them, replicate or are replicated in a number of the new code. So 3A of the new code is to be found in 2.1A of the old code. And
So your submission is that because the Law Commission read in the word physical, so should we?
as with any approach to construction, one is looking not for a particular comment which is decisive. It's assessing an accumulation, a body of material. I'm not suggesting because the Law Commission said it's physical work, it therefore is physical work. It's indicative of what the Law Commission thought that those code rights meant. That is of some use to this tribunal in determining the appropriate interpretation of the code. It's one of a number of things. The other matter I would wish to draw your attention to, my lords, are some other provisions of the code, which I trust are also in the bundle. If we go back to the code, which I believe is in tab 17, and if your lordships would turn to paragraph 59, which is page 639 in the top right hand corner. Your lordships have that.
Yes.
So 59 subparagraph 1c is a right to carry out any works in, on, under, over, along or across a street. This is part of the special regime, but it does make a reference to carry out any works. And then we see in subparagraph 2 that the draftsman has provided a definition, not exhaustive, admittedly, but it includes breaking up or opening a street or a road, tunnelling or boring, breaking up or opening a sewer. That's, again, a modicum of support that the draftsman, when he was talking about works, was thinking about physical work.
So, if I want to run ultrasound surveying equipment down a street, do you say that's within this or outside it?
I would say it's outside it. Again, it's the purpose. We're dealing with a slightly different matter because, of course, the MSV is to determine suitability. So it depends upon the context of as to what is being done. And if it's part of the installation, so that you are actually installing it, obviously you then have to, let's say you're going to install it into, you're putting some sort of street furniture, which is often referred to, where you attach electronic communications apparatus. It looks like a lamppost, but it's often referred to as street furniture. You may want to put a...
Paragraph 63, subparagraph 2 fit into this submission?
I'm sorry, I'm all in this.
How does paragraph 63, subparagraph 2 fit into this submission?
Well, other than the fact that, again, it just refers to works, and the works include placing a physical structure, a buoy or a sea mark. That is something physical that is being undertaken. You're not measuring it, you're actually taking it out there and placing it somewhere.
So if I take a boat over a tidal water, that's not covered?
Take a bite, well, the one is, in the example your lordship has given, is moving away from the right conferred in 63. Apologies, I just lost my place. Yeah. Of course, this is a right to install as well.
If I've got a boat with sonar surveying equipment, that's not covered?
The right to install must we come back to what you're trying to do. The right to install, let us assume that you're installing something, yes, over the tidal water, you're on the boat. We accept that a right to install would include a right to enter to install. And so you're wanting to install ECA, it must include a right to go onto the property to install it. We accept that. Therefore, coming to your lordship's example, if you're installing ECA over the tidal water, utilising a boat to reach your destination where that piece of ECA is going to be installed, that is part of the right to install. We accept that. My Lord, may I move on from that? I wish to deal next with the question of implied term, because the learned Deputy President decided that if it was not within the express terms, it was within the as an implied power, relying on Attorney General and Great Eastern Railway. We say that the test is not one of reasonableness but necessity. The question is it necessary to read these words into the statute? Given that this is an interference with private rights, there is a presumption against the implication. That is the decision of Sainsbury's Supermarkets and Wolverhampton. That refers to compulsory purchase. That approach was adopted by the Deputy President in the decision of CTIL against Compton Beecham.
In which case?
In CTIL, my lord, against Compton Beecham at the upper tribunal level. That is tab 4 of the additional authorities.
Additional authorities, by that you mean
Red spined
supplementary bundle.
Yeah, supplementary bundle. And he deals with that at 86 and 87.
Which tab?
Tab 4, my lord. Do you have that? Paragraphs 86 and 87, please. It says it's important to bear in mind when considering the effect of Part 4 involves the imposition by the tribunal of intrusive rights on unwilling parties. It is probably regarded as a variety of compulsory acquisition, and we consider it should attract the same cautious approach to its interpretation as always been applied to powers of compulsory purchase. That approach was considered by the Supreme Court, and then he refers to that. That's in the bundle. Summarising their effect as follows: the courts have been astute to impose a strict construction on statutes expropriating private property and to ensure that rights of compulsory acquisition granted for specified purposes may not be used for a collateral purpose. He referred also to Prest, in which Lord Denning said that it is a principle of our constitutional law that no citizen is to be deprived of his land by any public authority against his will unless it is expressly authorised. Finally, a decision of the High Court of Australia, in which, referring to private property rights subject to compulsory acquisition, French CJ said, where a statute is capable of more than one construction, that construction will be chosen which least interferes with private property rights. So, that is also reflected in the other decision which we rely on, which is in the the first bundle of authorities, volume 1, tab 5, the decision of British Waterways Board and 7 Trent, 2002, Chancery, tab 5, decision of the Court of Appeal. That was the extent to which there was an implied power to discharge water from a provision enabling a pipe to be laid, and the implication was not upheld. And Lord Justice Peter Gibson on this point, pardon me, we find mentioning this, apologies, I just lost my reference, my lord, apologies. Yes, paragraph 36, my lord. Paragraph 36. and it was common ground between the parties at the hearing before this court that STW needed the implied statutory authority for which it contended, because to discharge water on another's land would be an interference with private rights, even if the discharge caused no damage. As the judge rightly recognised, there is a presumption that a statute does not give the right to interfere. This presumption will yield to a sufficiently clear intention in a statute, as the House of Lords in Allen and Gulf Oil. And then he mentions that. So we say the presumption is to be cautious, not to imply the term. And we say, as I've submitted, the test of general necessity. Is it necessary to imply the words into the statute? In relation to the implication, what we assert, what we submit is that, as you may have seen from the skeleton, this is a power which is incidental to the incidental. The incidental right, as with the boat, is a right to enter, to install the ECA, or to go on the boat to install the ECA in tidal waters. But there is a right, and we accept a right to enter, to install the ECA. But the right to determine whether or not it is suitable for the installation of the ECA is incidental to the incidental right. Authority for that is the McCarthy and Stone Authority at tab 3 of bundle 1 of the authorities. This is in the Court of Appeal. McCarthy and Stone in Richmond. This is to do with whether or not there could be implied a right to charge for pre-planning advice. Clearly the local authority had, it was part of their function to deal with planning. And we see, if one turns to page 66, at the bottom of page 66, letter G, it is agreed that in order for pre-application advice, the Council needs a further statutory authority, and that authority must be found, if at all, in section 111. Either in express or by necessary implication, and then they refer to the section and note the words at the bottom, which is calculated to facilitate or is conducive or incidental to the discharge of any of their functions. And clearly they had a function as a planning authority. The question was, were they entitled then to charge for the pre-planning advice? And that is then dealt with by Lord Lowry at page 70, letter B. It is accordingly clear that the consideration and determining of planning applications is a function of the Council, but the giving of pre-application advice, although it facilitates and is conducive and incidental to the function of determining planning applications, is not itself a function. Thus, it is one thing to say that the giving of pre-planning advice facilitates or is conducive or incidental to the Council's planning functions, but it is quite another to say that for the Council to charge also facilitates or is conducive or incidental to those functions. The Council presented its case on the basis that charging for the service facilitates or is conducive or incidental to the giving of the pre-application advice. But even assuming that to be a fact, this way of presenting the case would simply amount to saying that imposing a charge facilitates or is conducive or incidental to a service which in its turn facilitates or is conducive or incidental to the Council's planning function. The developers, on the other hand, submit that in order to qualify as something which is authorised, the imposition of a charge for pre-application advice must facilitate or be conducive or incidental to the planning functions themselves. If not, the developers contend the charge is not within the powers of the council, since it is admittedly not authorised by any provision outside section 111. In this connection, the argument that something which is incidental to the incidental, but not incidental to the function, does not pass the test. Sorry, does not pass the test is not a novelty. See Attorney General. And then it was held right at the end of the judgment, page 75. He then says, apologies, at the bottom of the page, let's pick it up at the bottom of page 74. As the court has said,
Incidental to the incidental again.
it's incidental to the incidental, yes, thank you. And that is what we say this is.
But that was a question of construing and applying section 111 of the Local Government Act.
I agree. And we are asking ourselves, how do we interpret the rights that we see in paragraph 31A and 31D? The right under 31A is a right to install. The right of entry is clearly, we accept, an incidental power to the right to install. The right to enter to install must be a right that it will be ancillary. But the right to enter, to undertake an MSV, to determine whether or not you wish to install, is incidental to the right to install. It's one remove back. You're asking yourself, do I want to install? You may never install. It's incidental.
The installation is a right, it's a code right.
Yeah. And the right to enter to install would then be incidental to that.
That's a substantive right. The installation itself is a substantive end right.
Yes.
It's not incidental to anything else.
But the right, there are rights to enter the property, presumably to effect work, to be able to install.
That's
The
all
paragraph A doesn't.
Now, I think what you're saying is that there are express rights to enter the land for certain purposes. Installation of electronic communications apparatus is not one of them. But you accept, if you wish to install electronic communications apparatus, it is an implied right, incidental to the right of installation, that you can enter the land for that purpose.
Yes.
If, on the other hand, you don't know whether you wish to install electronic communications apparatus, but merely wish to see whether that's feasible or economically viable or whatever, then that is incidental.
That is
Incidental
our
right to
submission.
enter
That is
to
our submission.
install electronic communications apparatus.
Yes.
I think that's how this
That
argument runs.
is my note. Would that be a convenient moment?
Yes, now, I'm slightly concerned about time.
Yes.
How much longer are you going to be? Because
I'm
Mr.
sure-
Singh's got to have his
Well,
say.
absolutely.
We have discussed some.
Yes,
extent.
we have
It's your
discussed
second-
the
second
issue, but I would like just to sort of bring out some of the points that we didn't discuss when we were going through the provisions.
How
of
long
the
do you
code.
think that's going to be?
I would suspect not more than an hour, my
I
lord.
don't think we'll have that long.
Well, if your lordship tells me how long I have, then I will.
I think the most you're going to have is half an hour.
Thank you.
Guys.